filling up their forms is tomorrow. So may I pay that may be listed tomorrow, Your Lordship?
Investigated for
Prosecuted for rigging, Your Lordship.
ragging.
Yes, I'm challenging the quantum of the punishment, Your Lordship. That is been revealed.
But these are menace. Okay, I'll permit you. All the requests for listing, please give it to the court master. They may have to adjust.
May I please, Your Lordship? Lordship, this matter relates to regulation of some
Give
cases
it
and
to
papers.
the
Yes,
court
madam.
master.
This may be posted on Monday, my lord.
I'm not doing it. Let the court master do it. I
Yeah,
don't
please.
know my roster.
May I please?
They will have to make some adjustments. I can't give a fixed date.
My lord, the bench, court.
I understand, but I can't give it. Let the court master decide. The matters, how many matters I have listed to them tomorrow, I don't know. They'll have to make some adjustments. I'm not denying you, but I
Yes.
can't give a fixed date. Let the court masters will have to adjust.
Okay.
Also, my mention memo, I was mentioned this matter yesterday, before yesterday. Your Lordship allowed this matter, but subsequently it was rejected.
No, it was rejected
Yes.
because I asked you. You said that the bench was not there, and
Yes,
on that
it's
day the bench was
available, but
taking up.
in criminal way.
No, the criminal bench was yesterday, not on
No,
Monday.
before that also criminal.
It
way.
was not there. I checked the list. I checked the list. I got the list. I
Yes,
checked
but
it.
it-
That's why I asked you. On Monday, the honorable bench was taking up the matters. It is on Tuesday that it was not listed. Tuesday or Thursday. Yesterday was Wednesday.
Yes.
Wednesday, the honorable bench was taking up bail matters. I got the list. I checked it.
It may come out from.
Because.
Chief, I beg to mention item 5 of today's daily list, Lordship.
Yes,
Bring
right,
it.
2017 matter, you are taking an adjournment.
Lordship, my CDI has got some difficulty today. And so it will be taken up in the next week, Lordship.
I can't, this matter was came last week also.
Yes. Lordship.
It was adjourned. No, not at all, because
Lordship,
come
at 30th,
after.
that day,
No,
to some
I can't
extent.
help it. I can't keep your matters being listed.
Lordship.
If I'm listing your matters, some other matters are not being listed. That is why you see, in the last mention, the learned lawyer was dissatisfied. The matters are in the board. And then every case adjournment is taken, and the people who are wanting to do, they can't do it. I can't keep listing your matters continuously. Even if you have an urgency, it goes after 2 weeks. Once you take in the old cases and adjournment, it goes for 2 weeks. I can't keep your listing your matters only. That is not the only case I have.
I understand.
No, that request will not be acceptable. If you are taking adjournment 2017 matters, better take it for 2 years, 3 years.
Today we have got some difficulty. Lordship.
No, your difficulties will always be there. What is the guarantee that tomorrow there will be no difficulty? In a man's world, it's not a man's world, it's a world designed by the Almighty. You don't know what is in store tomorrow. No, after 2 weeks. I'm not giving a fixed date.
Any date, Lordship.
I'm not giving a fixed date. I'm absolutely dissatisfied with 2017 matters being adjourned.
Lordship. Obliged, Lordship.
May I please, Your Lordship? Item number 59, my lord, part 2 list, my lord. In this matter, my lord, some matter pertains to non-payment of salary, my lord. Some subsequent development is there, my lord. So, my lord, the instruction may be required to file additional affidavit, my lord. Some payment is already released, my lord. But though the petition
59,
may
59, you can always file, this is for the entire month. You want more adjournment.
no, my lord.
This is for a monthly
After-
list. It's a monthly list. You do it in 7-10 days within the currency of that list.
I have instructed my lord. Though my lord petitioners are already their services regularized and
Okay, on
confirmed.
the prayer made by item 59 part 2. On the
After
prayer made
2
by
weeks,
London
my
Council for the petitioner, the matter stands adjourned and off-listed. List in the next monthly list.
My lord, 66 is on same.
Same 66.
Daily list item number 1 and 2 for delivery of orders.
In this, both the petitions are dismissed. Obliged. There's some corrections I couldn't do yesterday.
Well.
We released the second half.
Development Commission.
Item number 3. For motion,
My lord, this is the second time, second bail application, my lord.
Where is the previous order? Which page?
My lord, on page 17, my lord.
17.
My lord. Well, it was rejected on 24/8/2022.
Okay, get the scan copy of the updated case diary.
My lord.
You don't need the original case diary.
My lord.
Get the scan copy or relevant or status of investigation.
My lord. Well, from Polasbury,
When-
it come original also from my lord. Original may also come from
Oh,
Polasbury.
you see, these cases, going by the nature of the offense,
My lord.
you, we don't want that for case diary, the charge sheet
Hmm.
filing will be delayed. That is something I don't want.
Same.
When? Today is 11th,
My lord.
get it by 17th?
My lord.
My lord.
17, my lord.
Okay.
Ali.
or
My lord, it is also earlier rejected, my lord, after going to the case diary, my lord.
lord,
Lordship, page 14, my lord.
Kindly can pass over for the time being, my lord.
No, I'll have to call the case diary.
My lord,
Just
14.
wait, let me go through it.
Page 14, my lord. Rejection order.
106. Okay, same order here also.
My lord.
This is from which place? Agomani.
Agumani.
Same day, 17th.
My lord.
Scan copy of the case diary or status report of investigation.
Okay.
Obliged. 17.
I for admission,
Obliged.
No, 5 is adjourned.
2 weeks.
5 is adjourned for 2 weeks.
6 for hearing,
Lordship, in this case, senior advocate Mr. B.C. Das will be leading me. Senior advocate Mr. B.C. Das will be leading me in this case, Lordship. He is in legs in court number 12. Can it be taken after 5 minutes?
Okay, after some time.
Deeply obliged.
7. Item 7.
Yeah. Reading. Division to the one. Okay, this is 7. It is observed that the name of the learned counsel for the petitioner is not reflected in the cause list. Perhaps for this said reason, the counsel for the petitioners are not present. Next, the registration indicate the name of Mr. P. K. Das from a counsel for the petitioner. In the cause list. Along with other counsel, if any, in the Wakalatam. List the next week. Just show that name, P. K. Das. P. K. Das, we can inform him also, P. K. Das. Item 7.
But SC higher education, name of the standing council higher education may also be shown, my lord. Because they are the necessary party, my lord.
Okay.
Otherwise, I appear for respondent number 3, my lord, the chief secretary, my lord.
You can write, Mr. G. P. Good and government advocate is present. History shall also
Number 3, my lord.
reflect the name of SC higher education by listing the matter next. Petitioner and higher education, given a single paragraph. Yes.
8,
Yeah, please, Your Lordship.
Yes, Mr. Babu, yeah.
My lord, this case released to the promotion, my lord. Petitioner is working under my lord, Director of Technical Education. And he's seeking promotion, my lord. From planning officer to research officer. To that fact, my lord. The concerned authority, my lord. Prepared a draft list, my lord.
Yes.
Draft list, my lord, draft service law, my lord, that I have prepared. And my lord, that has not been acted upon, my lord. And technical director, my lord, filed an affidavit saying that, my lord, they have not.
Promotion to the post of research officer.
My lord. From planning officer, my lord. And director technical education, my lord, said, my lord, there is no service rule in respect of the planning officer under the director of technical education. No enactment of the rule of the planning has been taken by the authority, my lord. Only the contention of that much.
Where is the draft service rules?
My lord, I have annexed in my read petition, my lord, that your lordship will see at page 27, annexer 6.
Page?
Page 26 or 27, my lord. It starts from 26, but this operative part starts 27 onwards. Operative part of the rule, my lord, 11, 12, and 13. That your lordship will find at page 29.
Yes.
Rule 11.2, my lord, if your lordship turn to page 29, my lord. Recruitment by promotion, my lord, rule 11. And in the instant case, my lord, it will be rule 11, sub rule 2.
Yes.
subject to the suitability as may be decided by the board and by the appointing authority, an officer belonging to the post of planning officer in the Assam Technical Education Planning Service shall be promoted to the post of research officer in the manner provided in Rule 12 and 13. 12 says, my lord, 12 says, my lord, before the end of each year, appointing authority shall make an assessment of likely number of vacancy to be filled up by promotion in the next year, each cadre. Number 2, my lord, appointing authority shall furnish to the board following documents, information regarding as may be mentioned so and so. Then lordship kindly turn to the page 30, rule 13, my lord, the operative part, my lord, otherwise I'm skipping, my lord. Rule 13 says the promotion shall be made in accordance with the list approved by the board reflected in Rule 11-12 shall consist the following. Board considering promotion of research officer, secretary, senior most so and so. These are the board, how it will be affected. Now, my lord, before coming to the draft rule, my lord, the concerned authority by letter dated, my lord, page 24, annexure 4, made certain queries, my lord.
Yes,
Page 25, my lord, lordship will see annexure 4. The authority made, my lord, director from director to government level, my lord. There is no service rule in respect of the office planning officer who under director of technical education, cadre assistant, planning officer 1 and research officer 2. Chandrakanta Rajbangshi, planning officer, date of joining is the 1st November 1990 and so Bharali of 2011. One number of post of RO is lying vacant. Annual confidential report for 5 year so Rajbangshi planning officer enclosed here. Special and integrity report of Chandrakanta Rajbangshi is enclosed. There is no any DP or vigilance case has been pending or contemplated against the Chandrakanta Rajbangshi. That is the instant petitioner. The roster point is 8 category reserved. And scale planning officer so and so and planning officer of the director is a single post and there is no gradation list. That has been acted upon, my lord. To that effect, my lord, before preparing the service draft rule, my lord, I have made a categorical statement in my paragraph 5 of the writ petition, my lord, at page 9. At 9, my lord. Though I have got the copy, my lord, last occasion I have submitted the copy. Page 9 be seen, my lord. The petitioner begs to state that respondent authority have already adopted and followed the draft service rule, which had duly been accorded approval by the authority of legal remembrance of Judicial Department, Assam Public Service Commission, including the authority of Personnel Department. So to the implement the same in terms of drafts rule. The rule of the present post of research officer is a promotion to directly from the post of planning officer is governed by Rule 11-12. Just now I have shown, my lord. And if your lordship permits me, my lord, I have got the copy, my lord, of the approval, my lord. Maybe they are in the record, my lord, loose sheet I have given on the last occasions. Now, my lord, what happens? Similarly situated persons, my lord, they have been given promoted, my lord, that your lordship will see annexure 7, page 33A. Annexure 7, my lord, subject to the revision without noticing, without assigning any reason, so and so planning officer, director of technical education is hereby promoted temporarily until further order, cadre of the office research officer in the office of the director so and so. This has been issued, my lord, 1995 to another person. Then next page, my lord. Annexure 8, my lord. In furtherance to the approval accorded by the Assam Public Service Commission, appointment of the research officer on promotion under Regulation 4D of the APSC Regulation 1995, so and so in respect of Sri Abdul Hachib is hereby regularized with effect from date of so and so 1995. Other persons, my lord, in the same office have been given, my lord. And now, my lord, I file my additional affidavit, my lord. Lordship will see my Lordship will see, my lord. The affidavit reply filed by me, my lord. That your lordship will see page 5, my lord. Which I have
What is the
filed,
name of the person for whom this draft rules was applied?
my lord.
Which document you gave us?
Approval, my lord, and 2 sets of judgment, my lord. If it is not there, my lord, I can supply it. Maybe must be with the record, my lord.
You are referring to this documents relating to approval.
Yes, my lord. Approval of technical education higher secondary. Then lordship will see technical education department. This is also under Secretary of Finance.
What are the judgments? I don't have it here.
My lord, judgment I'll supply, my lord. Just coming to that, my lord, I'll supply, my lord. That approval part also I'll come later on, my lord. Lordship, before coming to that, my lord, which I have filed an affidavit on 11/10/18, my lord. Lordship will see page 5. I have enclosed the document as an annexure 10. Mon and oh, that is 8 number to mention Boribon Lordship.
Affidavit in reply.
My lord.
Yes.
Lordship will see page 5, annexure 10.
Yes.
In the interest of public service, Sri Chandrakanto Rajbongshi, planning officer of the director, is hereby directed to functioning as a research officer for smooth functioning of the official work with effect from 2/7/12, in addition to the normal duties.
Lordship,
It has been given by the director.
may I pay for the passing of the matter for the time being, Lordship? Because Mr. Kehu is handling and the time.
Okay. We'll hear you after some time. Let me, sir.
Lordship.
It will take some time, my lord.
Yes.
Then, my lord, lordship, I was allowed to work, and by virtue of the interim order, my lord, initial interim order, one post of research officer was kept vacant, my lord. And in that post, my lord, I am still working, my lord. Now, my lord, what happened? The respondent number 7 filed an affidavit, lordship.
Just tell me, supposing this draft service rules was not there, then what was the law which was followed?
If that rule is not there, my lord, it is up to the department, my lord, what to do and how to deal, my lord. Since there is a draft rule, my lord, concerned authority made inquiries, they ask for the document, one after another, authority department has provided, my lord. And to that effect, my lord, there is a due judgment of the apex court holding that, my lord, if the draft rule has been approval or is likely to be promulgated next time, that can be acted upon. That judgment I'll supply to your lordship. I have, my lord, only one copy, my lord. Can I?
Just give it to us. We'll
Lordship. I have my only one copy, my lord. It will be, my lord. True judgment, my lord, yellow mark portion, lordship can see, lordship can have access from internet also, my lord.
আপনার টাইমিং গুলো বলে দিই
Yellow mark, my lord, I'm sorry for that, my lord, I have marked for my convenience.
টাইমিং গুলো বলে দিই তো আমরা টোটাল জানি এবারে আপনাদের এক্সাম
একটা photocopy করে দিন। এটা কোয়া। এর উপর আনিব পারিব তুমি। এক মিনিট দাও। এক মিনিট দাও।
Okay.
That, my lord, can be acted upon. Now, my lord, during course of hearing, my lord, the honorable court, another bench, my lord, asks for the hierarchy of the status of the present office, my lord. The hierarchy has shown, my lord. It seems, my lord, it cannot be accepted because, my lord, lordship will see from extreme right, from grade 4 to joint assistant.
Extreme
junior
right
assist-
of, extreme right of what?
My lord, is the affidavit filed by them filed by respondent number 7. I have received copy on 23/5/22.
Yes.
Lordship will see extreme 2 lines, my lord, extreme right hand side. Lordship has seen, my lord, first extreme right hand side, grade 4 assistant editor, then assistant research officer, one post deputed from the Directorate Economics, Assam. Then, my lord, it seems that his promotion is going to be, my lord, deputy, my lord, director, my lord. To direct, he can get a grade 4 person up technical director. This is not correct. As because not correct, my lord, lordship will see the reply of this, my lord. I have given. Reply of this, my lord, I have given, my lord, because
We may not go into it because you see, this is not your prayer in the writ petition
yes, my lord.
that the rationalization of the post should be done. That is not your case.
Not my case. My
So
case
therefore, why
is
should
simply
I-
my promotion because for the want of,
Your case is simply that you say that the draft rules should be enforced, only that
yes, my
much.
lord, only that much, my lord. Now,
So
lordship
whether-
will see, my lord, similarly situated persons, my lord, to counter the roster, my lord, just for convenience of the court, my lord. Lordship will see, my lord, they have, I have annexed, my lord, annexure it to the reply of this, my lord. I'm just skipping direct to the serial number 3, my lord, at page 8, annexure 1.
Yes.
Serial number 3, lordship will see Vipul Datta, senior assistant, a junior editor against the so and so. Then lordship will see the next page 9, Vipul Datta, assistant director of technical education, Kahilipara. Then very person, my lord, page 10. Vipul Datta, assistant editor assistant editor, assistant research.
I'm not
officer.
being able to follow you. What you're trying to show,
Right,
I'm
so my
page eight.
lord, though my lord lordship is not going into that, my lord, hierarchy, my lord. Because they said, my lord, they made their own, my lord, maybe for administrative purpose, not for the promotion of all, my lord, because other junior persons or junior fellow officers also, my lord, they have been given promoted. To that effect, lordship, kindly turn to page 10, my lord. Vipul Datta, assistant editor, assistant research officer, so and so. Next page, my lord. Orders by governor, promotion committee held on so and so, subject to the discharge. Superintendent of the technical education of director, he has been given promotion to the technical, my lord. So hierarchy cannot be taken account, my lord. Though they have filed their affidavit. So now, my lord, question comes before your lordship, my lord, though they have taken all the formalities and similarly situated persons have been provided promotion, my lord.
Mr. Bobby, I'm not being able to follow you. You see, you have shown me page 10.
Yes, my lord.
You are referring to Vipul Datta.
Vipul Datta, my lord.
He is an assistant auditor,
My lord.
correct?
Yes, my lord.
He is promoted to research assistant,
My lord.
correct? That is what you are showing me.
Yes, my
This
lord.
is in 2018.
18,
In the next page, it is of 2020.
my lord.
Here, his designation was given. Department promotion meeting discharge without notice, so and so. Vipul Datta, senior assistant.
My lord. On the recommendation of the
No,
department,
no, no. His post is senior assistant,
my lord,
not research assistant.
my lord.
So there can be many people of Vipul Datta.
No, my lord. To counter the hierarchy, they have filed.
No, I must understand what you are trying to argue.
Yes.
You are showing me in the first page,
Oh.
Vipul Datta was assistant auditor.
Yes.
He
my-
was promoted to assistant research officer.
Ah,
This is in 2018.
my lord.
In 2020, you are showing me a Vipul Datta
Ah,
who was the senior assistant.
my lord.
So one person who is a senior assistant were promoted.
My lord.
So whether senior assistant and assistant research officer are same, I don't know.
No, my lord. No, they said from the hierarchy, my lord.
No, let them, you see, let them be what they are saying.
My lord.
You are making an argument now. You are not arguing for them.
My lord.
You are arguing for yourself.
My lord, I'm arguing for
No,
the.
no, please reconcile page 10 and 11. That is the only thing I want to do. Learn. So there may be hundreds of people that are in the same.
Yes, my lord.
In our court also, you find the similar
Yes,
names are there,
yes.
one or two.
Yes. Sir. So far, my lord, just I have annexed this document just to counter their hierarchy
No.
they have
You
filed,
see, there must be some logic.
my lord.
What is that logic?
Logic is that, my lord, the hierarchy, what they have submitted before the court, it is
But
not correct,
if these two people are not same, why should I hear you?
my lord.
This Vipul Datta, you see, you are showing me a document by which he was promoted to assistant research officer.
My lord.
In the next page, you are showing me that Vipul Datta, who is the senior assistant,
My
he
lord.
was promoted.
He was promoted.
So a man is promoted to assistant research officer. He is also working as senior assistant.
My lord.
That is what you are trying to say.
No, my lord. I want to say, my lord, the hierarchy, they said, my lord, grade 4, 5.
You see a very simple thing. There is a Mr. A.B. in my court who is a peon.
My lord.
He is promoted to grade 3.
My lord.
There is a A.B. who is a court master. He is to be promoted to assistant registrar.
My lord.
Correct.
Yes.
Then there is another A.B. who is a driver. He has to be promoted to chauffeur.
My lord.
So can I read all these 3 papers and come to any conclusion?
No, my lord, not that, my lord.
Then-
Only because my simple contention was that, my lord, whatever they filed the hierarchy structure, that is not the correct. Anyway, my lord, this is not in the case, my lord. My simple case is that, my lord, whether, my lord, draft rule can be acted upon or not. My lord. And to that effect, my lord, I made a categorical statement and approval copy is also there, my lord.
Yes, Mr.
Like-
Gogoi.
Dear Lordship, in this case, we have filed affidavit, Lordship. We are stating that, Lordship, government is not, government, there is no any decision taken by the government for, Lordship.
No,
that
the
they have
question I'm
notified-
asking is,
Lordship,
Assuming that there is no draft rules,
Lordship.
in that event, how the people in this department are promoted?
Lordship, it is by deputation, Lordship. Deputation from other department in respect of research officer, Lordship.
In this,
Lordship.
in the absence of rules, you take on deputation.
Deputation right, from research officer. In APSC, Lordship, it is from deputation.
But it's a promotional post.
From research officer is a Lordship, promotional point hierarchy is there, Lordship. We have given it, Lordship. In our additional affidavit, Lordship.
No, but if it is a promotional post,
Lordship.
when you admit it is a promotional post, how you can bring someone on deputation?
Lordship. Till today, Lordship, no any rules is there. That's why
No,
it's
I
from
understand,
deputation.
but
Lordship.
once the department takes a stand, it's a promotional post.
Lordship.
How can it be filled up by deputation?
Here only hierarchies we have given, Lordship.
Hmm.
It's from grade 4 to assistant auditor, then Lordship assistant research officer, then Lordship research officer, Lordship. In page 3, Lordship.
No, correct. It's,
Lordship.
this is prepared by whom?
Also, it is by Lordship, the Director of Technical Education, Lordship.
Where is the statement to that effect? You see, Mr. Gogoi, I'm asking you because I have a wrong way of reading.
Lordship,
I read from the last page first.
Lordship,
In your affidavit, it is not even verified.
Lordship.
The statement you are making, you have made this a part of your statement in para 3.
Lordship.
You are not even taking a responsibility. You are taking best of my knowledge. A
Since,
departmental authority,
Philip, since I have derived it from records, Lordship,
which record?
Lordship,
Once you take a statement, it's true to my knowledge.
Lordship.
Then it has to be verified from the knowledge alone.
Right.
Once you say it is from the record, then you have to disclose which record.
Then Lordship, I can place the report also, Lordship. If Lordship permit, if it says that Lordship, based on my knowledge, belief, since I have derived it from records, Lordship.
No, it's okay, because you see, if supposing I am a man of authority,
Lordship,
I only want my grade 4 staff to be promoted, only my secretary to be promoted, my court master to be promoted.
Lordship,
I bring out my own, what you call chart.
Lordship.
Tomorrow you become the head of your office. You start promoting your own people.
Lordship,
You want your staff to be promoted.
Lordship.
This is not how the government should run.
This is the Lordship, all the staff pattern of the Directorate of Technical Education, Lordship.
No, but there should be some record of what they are
Lordship.
maintaining.
If Lord permit, I can place it, Lordship.
But there has to be some record.
Lordship,
Otherwise, why would you accept something, a statement made by this Bora,
Lordship.
Director of Technical Education? You don't say that which record he has consulted.
Apart from this, Lordship, petitioners, Lordship,
No, not that, but you see, there will be a heartburning.
Lordship,
Let us say in this chart,
Lordship,
you are at, you put yourself into this situation. Now this joint director, registrar, superintendent, senior
Lordship.
assistant, stenographer, draftsman. Now, if a person comes into the hierarchy of this service, he is first a grade 4, then a
Lord-
machine operator,
Lordship,
then a daftari, then a
Daftari.
junior assistant, then a
Lordship.
draftsman, then a stenographer,
Lordship,
then senior assistant,
Lordship,
then superintendent assistant, then registrar, then joint director, then he goes to technical director education. If somebody comes in the third column, he
Lordship,
is first grade 4, junior assistant, senior assistant, training cum placement officer, then director. He jumps.
but Lordship, the director, it is the director post, Lordship, is a direct recruitment post, Lordship.
No, supposing I am qualified,
Lordship, Lordship,
I have the qualification to become the director.
Lordship,
Now, see, if I join this column
Lordship.
3,
Lordship,
then in third tier, I reach there.
Lordship.
In the other, he gets 1, 2, 3, 4, 5, 6, 7, 8, 9,
It should
10.
be Lordship Directorate of Technical Education. Yes,
No, whatever be, but this is 11 tier.
Lordship.
He may not reach, a person will never reach a post of director.
Lordship. Director is a direct recruitment post from it. Now it is a
I
PSC.
understand. That is, we assume the worst.
Lordship, Lordship. Lordship.
Great for a man, you see, if, Mr. Goe,
Lordship.
this is not a, it's a very difficult world.
Lordship.
About a year back, there was a news from Chennai
Lordship.
that for the post of sweeper, about 22,000 engineers
Lordship.
had given their
Lordship.
engineering graduates gave their application
Lordship.
for Safai Commissary in Chennai.
Lordship.
So if people are unemployed,
Lordship.
a highly qualified person can use just feel that they will join grade 4.
Lordship.
He's qualified to become a director. He joins, he has no work, he joins as grade 4.
Lordship.
So there must be some rationality in the post.
Lordship.
Because if two people are similarly situated,
Lordship.
you are stagnating, and the other side, others who has joined along with you,
Lordship.
in 3 jumps, he goes to the post of director.
Lordship.
And if you are the grade 4 in the column 4, you have 11 promotions to be,
From get photo join director. Lordship.
yes, 11 promotions you'll have to undergo.
Lordship.
So this is irrational.
Lordship.
In the third, the fourth, fifth column also, grade 4, junior assistant, senior assistant, planning officer, and director.
Lordship.
But then
This
you have to take
hierarchy was
a,
placed because Lordship petitioner says that Lordship from the planning officer, Lordship research officer can be from the post of planning officer, research officer is the promotional post. Lordship.
yes,
Lordship.
assistant research, he says that it's a promotion,
Lordship.
but then you'll have to consider him for promotion, even there is a, what do you
Lordship.
call, even if there is a draft rule or no
Research
draft rule.
officer from the Lordship assistant research officer, or assistant auditor, then assistant research officer, then Lordship research officer. In case of planning officer, Lordship, junior assistant, senior assistant, and planning officer, Lordship.
So consider him.
Lordship.
If
From the
he is,
post of planning officer, Lordship, there is no provisions for promotion to research officer, Lordship. So he insisted that Lordship draft rule should be Lordship implemented, Lordship. That basic care of the petitioner is Lordship, that Lordship draft rule should be implemented and give him promotion, Lordship.
you are a planning officer. Mr. Gogoi,
Lordship,
if I'm understanding you correctly,
Lordship,
you are saying that the planning officer is the highest post.
Lordship,
There is no further avenue of promotion for him.
Lordship.
Is this what you're trying to say?
Lordship, it should be Lordship Directorate of Technical Education Assam. That's it, Director of Technical. Typographical mistake is there. Directorate of Technical Education
So
Assam.
that is okay,
Lordship.
but
On the
planning,
post of planning officer, Lordship, there is no provisions for upwards,
any other upward
upwards movement,
mobility. Have you made that statement also in your affidavit?
We have said that Lordship, on the basis of draft rule, Lordship, he cannot be promoted, Lordship.
Come to your affidavit in opposition.
Lordship,
How have you dealt with it?
Lordship.
Okay. Mr. Barbaya.
My lord.
Where is the statement you made, which man has been promoted as per the draft service rules? Where is the statement in your affidavits?
Lordship, the petitioner had annexed two documents, Lordship. It is way back in 1995, Lordship.
Where is that?
It is in Lordship Annexer 7, page 33A, Lordship.
Similarly situated persons, my lord. A massive planning officer, director of technical education, page annexure 7, page 33A. Annexure 8.
It was issued in 1995, Lordship. It says that Lordship, so and so,
This is only an officiating promotion.
Lordship. A temporarily.
Next page, my lord, it
temporary
is being
engagement.
confirmed. Assam Public Service Commission appointed as the research officer promotion under regular reform. Government of Assam by in respect of Sri Abdul Hasib is hereby regularized. Last page.
So that is an appointment made by the APSC.
No, my lord, APSC, they made and they.
It's a
There was
1999,
So
Lordship.
APSC, it is 4D they are invoking.
Lordship.
What is 4D?
Under regulations 4D, Lordship.
What is 4D?
See, my lord, APSC rules mostly for temporary promotion, something like that.
Service reform.
Apart from this, my lord, I like to apprise, my lord. There is a two post of research officer, my lord. One post which I am holding. That is. Interim order is there, my lord, not to fill up that post. One post may be their own reputation. My lord,
Anything,
apart from that, my lord, lordship will
Public,
see.
Local X, public P.
Apart from that, my lord, lordship will see, my lord, page 35, my lord. The very director, my lord, has resigned to the government, my lord, seeking promotion of Chandrakanta Rajput. I have annexed, my lord, last page. With reference to the government letter on the subject cited above, I would like to state that there is no possibility of research officer transfer to the director of higher secondary Assam returning to the director of technical education. Further, I would like to state that Chandrakanta Rajbangshi, planning officer, has been doing satisfactory all the plan and non-plan related to the works for 15 years of this director. In view of the above, I would like to request government that Sri Chandrakanta Rajbangshi, planning officer, may be promoted against the vacant post of research officers of this director at an.
No, it's okay, recommendation by someone that doesn't make a law.
My lord.
Because then in the state of Assam, there would be no illegal appointment.
No,
Everybody is appointed by recommendation of someone.
my lord. Someone, his higher immediate boss.
It's
has-
okay, but that can't be a rule.
My lord, that cannot be. But over and above, my lord, by
Just,
virtue of the.
just a moment.
And now, my lord, I am barred of retirement, my lord. 59 years. Sometime this year or beginning, my lord, I'll get retired.
It's okay, this 4D is officiating promotion for a period which is not likely to last for more than a year. That is 4D. So it's not a permanent promotion.
My lord. Even though, my lord, I do not have service more than a year also now.
But that is okay, it can be placed before the authorities. But Mr. J.I. Borvier and counsel for the petitioner. And Mr. K. Goel and standing counsel for the higher education department.
If lordship permit, I can point out to judgment lordship permit.
Yes. For respondent number 1 and 2. For APFC who's appearing, no one?
Sir.
Are you there?
Yeah, we are formal party, we have nothing to
Ah, yes, but still.
Yeah.
You want me to record your name?
But I have seen, there is no pairing.
TJ Mohanta, senior counsel, assisted by Mr.
T Gogoi.
T.
T Gogoi.
Gogoi, counsel for the standing counsel for the APSC. Comma, respondent number 5 is personal department. Mr. Pegu,
My lord, may I record his name, I will.
Mr.
inform you.
G Pegu, the government advocate appearing for respondent number 5. Who is appearing for this finance, Shadia? Mr. A. Shadia for finance department, respondent number 6. Technical education,
Lordship, again.
Acha, then you against him, you write also 7, 8 and 9.
Lordship, I am appearing for lordship,
7, 8 and 9
1,
also.
2 lordship, 7, 8 and 9 lordship.
Ah, okay. Yes, what are these judgments you want to place?
Lordship, one judgment is lordship, our High Court Kohima bench lordship.
Kohima bench.
Lordship.
Udisul Loho. Oh,
Lordship, I have supplied the copy. Lordship. Paragraph 6 and 7, Lordship, I am relying.
what is the service rules here? Draft service rules.
Lordship,
What is the
regarding
name?
draft service rules is there, Lordship, in respect of Lordship.
What is the name of the rule? I just wanted to know that. Is it Nagaland Planning Service Rules,
Lordship.
2007? Is it
Lordship,
2007 rules?
Lordship.
Where is that? No, in this case, there was no draft service rules. Draft service rules are prepared in 83.
Lordship.
What is the name of the rule?
Lordship. Notification number is there, Lordship, yeah.
It's not there.
Lordship.
Uh, by filing this repetition in Article two twenty-six,
Another judgment is there. One is from Apex Court Lordship.
you just mark those paragraphs.
Lordship, just I'm point out Lordship.
Hmm.
1998 for SCC 114 Lordship. Here I'm relying paragraph 7 and 8 Lordship. I have supplied the copy Lordship. 1998 for SCC 114 Lordship.
7 and 8
7 and 8 Lordship.
and
And Lordship 1994 for SCC 42 paragraph 6 Lordship. Paragraph 6 Lordship.
6. Okay, I'll come to it when I there. Referring to the representation under Article 26 of the Constitution of India, the petitioner has prayed for a direction upon the respondent authorities to promote the petitioner from the post of planning officer to the post of research officer. Which is lying vacant since 2011. So the petitioner has also prayed that other than promoting the petitioner, the respondent authority should not fill up the vacant post of research officer in any other matter, or to fill up the post from any other department on deputation. Next paragraph. The petitioner who is having a qualification of BA is was initially appointed as a primary investigator. You are appointed as a computer.
My lord,
You are appointed as a computer.
no, my lord, I was been
Lordship, he was
recognized
initially
by
in a
Lordship
project
will
Lordship.
see at page.
He was initially in a World Bank project Lordship. After that expiry of the project period Lordship, he was adjusted as a planning officer Lordship.
No. In para 2, page 7, he says, I was appointed as a primary investigator, stroke
my lord.
computer.
Then, my lord, I have gone for
Lordship, I mean, our affidavit Lordship,
No,
paragraph.
that's okay, but that's what I'm asking him. You see, here, read the statement.
Lordship.
He was appointed as a primary investigator of the computer.
my lord.
So you can be appointed as a computer.
Lordship,
No, it's
investigator of the computer.
maybe my lord, typing mistake, my lord. The word
He was
thereafter-
Lordship, initially in a World Bank project
was
Lordship. This
appointed
project was completed Lordship.
No, not that, we are here,
Lordship, from the.
primary
next
investigator on
Lordship.
27/1987
Lordship,
in the office of.
Lordship.
Computer, my lord, by mistake, it has been typed out.
Case of the petitioner is after a stint of various of working in various departments, comma, the petitioner was ultimately appointed as research assistant in the Office of the Director of Technical Education, Assam, on recommendation made by the APSC. And comma, where he had rendered his service from 31/10/95 to 31/10/99. Full stop. After a stint of deputation in another service, comma, the petitioner was adjusted as planning officer by notification dated 30/7/2003, effective from 1/11/99. And the petitioner has been rendering service in the establishment of the Director of Technical Education, Assam. Full stop. It is claimed that the petitioner is otherwise eligible to be promoted to the post of research officer. And in this regard, the petitioner relies on the draft Assam Technical Education Planning Service Rules, 2013. Full stop. By referring to the provision of clause 2 of Rule 5 of the draft rules, comma, it is projected that the recruitment to the post of research officer shall be made by promotion only. Full stop. It is projected that the said post is lying vacant since the year 2011. Full stop. Accordingly, the petitioner submitted a representation dated 11/5/2011 to the authorities for being considered for promotion. Full stop. Next, the learned counsel for the petitioner has submitted that the draft service rules had received approval from the legal remembrancer and secretary judicial department for the make it number 1, legal remembrancer number 1. Then number 2 will be APSC, comma, number 3, personal department. Full stop. It is submitted that the promotion for the purpose of promotion, comma, the relevant rules would be Rule 11, 12, and 13 of the draft service rules. Full stop. The learned counsel of the petitioner has referred to the stand taken in the affidavit in opposition filed by respondent number 7, and has submitted that the plea that the draft service rules has not been implemented would not be acceptable. Because the draft rules has already received the approval from the various authorities. First off, it is submitted that one A Hachib, HACHIB, the then planning officer under the Directorate of Technical Education was given officiating promotion by an order dated 23/3/1995, and subsequently the APSC had regularized such promotion by its notification dated 19/7/1999. So accordingly, it is submitted that the said draft rules has been acted upon. So it is also submitted that the scale of hierarchy shown in the additional affidavit filed by the respondent number 7 appears to be incorrect to him because of the fact that there's no office of there's no promotional avenue for a planning officer. It is also submitted that from the documents annexed to his additional affidavits, the petitioner has demonstrated that in case of one Bipul Datta, the hierarchy as projected in the additional affidavit filed by respondent number 7 was not maintained. In support of his submissions, the learned counsel for the petitioner has placed reliance on the case of Abraham Jacob, ABRAHAM, Jacob, JACOB, and others versus Union of India, 1998, 4 SCC 65, and High Court of Gujarat and another versus Gujarat Kishan Mazdoor Panchayat and others, 2003, 4 SCC 712. Countering the submissions made by the counsel for the petitioner, the learned departmental counsel for the higher education and technical education has submitted that the draft rules is still at the draft stage and was not implemented. And the said draft rules prepared sometime in 2013 was not applied in the year 1995 when one HACHIB was promoted. First of all, it is submitted that so far as the records of Technical Education Department is concerned, So Directorate of Technical Education Department is concerned, the hierarchy as it stands has been laid down in the additional affidavit filed by the Director of Technical Education, Assam, within bracket respondent number 7, which was filed on 23/5/2022, under which the post of research officer is not the promotional revenue for a planning officer. Full stop. In support of his submissions, reliance is placed on the case of Ghaziabad Development Authority versus Delhi Auto and General Finance Private Limited and others within bracket 1994 4 SCC 42, Vimal Kumari, VIML Kumari versus State of Haryana and others 1998 4 SCC 114 and Engineer ER. Full stop. Kekhizale, sorry, KEKHRIE ZHALIE. Next word is SORHIE versus the State of Nagaland and others. WPC 111 within bracket K of 2015, decided on 27/3/2017 and reported in Manu MANU /GH /0054 /2017. Next paragraph. If the claim on a consideration of the materials available on record, if the claim of the petitioner to be entitled to promotion under the draft Assam Technical Education Planning Service Rules, 2013 is examined, it is observed that for the academic qualification required for direct recruitment to the post of planning officer is that the candidate should have the qualification of at least second-class master degree in statistics, mathematics, economics, or commerce from a recognized university or its equivalent, or degree of recognized university with mathematics, economics, or commerce as a subject, with 5 years experience in preparation of plan scheme and allied materials in the government establishment. Full stop. The petitioner has a qualification of BA from Guwahati University with English, Assamese, Maths, and Economics as his subjects. Therefore, the petitioner is otherwise having the academic qualification under the rules to be considered for promotion. Full stop. Nonetheless, the purported rules still being in a draft stage. Comma, the question which is involved in this petition would be whether a draft service rules could be enforced. Next paragraph. Next paragraph. To show that the draft rules has been implemented, the petitioner has relied on the promotion made to Mr. A. Hasib by notification dated 23/3/1995. First of all, on perusal of the said notification issued by the Joint Secretary to the Government of Assam, Education within bracket CTM bracket close department, it is observed that the said person was given an officiating promotion for a period of 1 year. Which was subject to for a period of 1 year. The APSC accorded its approval for the said promotion under regulation 4D of the APSC within bracket regulation, it was 1951. Such a promotion is permissible under the APSC regulation 1951. Therefore, it could not be demonstrated by the petitioner that it was on the basis of the draft rules that the same was acted upon and promotion was given to the said person. Full stop. No other example has been cited to show that any person was appointed in a manner which was prescribed in the draft rules. So therefore, the court is unable to accept that the draft rules were acted upon. Next one. Coming to the cases cited by the learned counsel for the petitioner. The relevant paragraph And, from paragraph 4 thereof, it appears that the facts before the Supreme Court of India was that from 1969, after formulation of the set of draft rules, promotion was being given to the junior engineers to the post of assistant engineer in accordance with the provisions contained in the draft rules. And therefore, the such promotions were given even before the draft rules were approved by the government authority. Full stop. In this case, merely because the approvals were given by various authorities referred above, would not mean that the draft rules was accepted by the competent authority in the government. And as it could not be demonstrated that the draft rules were acted upon, the case of Abraham Jacob within bracket Supra would be of no help to the petitioner. Next, in the case of Ghaziabad Development Authority within the Supra, the case also was cited by the Gun Council of the petitioner. The impress upon the court that there was a deemed approval of the bylaws merely because the legal remembrance APSC and the personal department had given their approval. Nonetheless, as you said, draft rules was not acted upon by the, at least by the Directorate of Technical Education, the court is unable to accept that there could be a deeming approval of the draft service rules by the government. Therefore, the said case also does not, it is not found to help the petitioner in any way. Full stop. These draft rules, as projected by the petitioner, was prepared in the year 2013, and that 10 years has gone by, and it does not appear that the government is serious about notifying the draft rules Full stop. At the cost of repetition, it is once again mentioned that as the draft rules has not been acted upon, comma, the court has no materials to presume that the government is keen to give a statutory character to the draft rules. This, I'm sorry, I made a mistake, I think. You had cited Gujarat, High Court of Gujarat.
My lord, two
That
judgments,
case-
my lord.
High Court of Gujarat, you had cited or you had cited?
No, he said, my lord, in the year,
Lordship, I am placing three judgment.
Bimal
Ghaziabad
Kumari was
Development-
relied by.
Ghaziabad Development Authority was placed by us, Lordship.
That was placed by you.
Lordship,
So
Lordship.
then I made a mistake, that's why.
My lord, I'd like to one point clarify, my lord, subject to lordship convener. I never said in the petition, my basing on the draft rule, the promotion has been given to anybody. That I never say. There are seven.
No, I've not put it in your words that it was done.
Lordship,
It's my finding.
lordship,
You are saying that to 1993, somebody was promoted, 95.
yes.
I am saying that it could not have been promoted by that rules which came in 2013.
My lord. I never said only that much. Lordship.
That case, what you call, Ghaziabad Development Authority is not by him, huh? This will change. High Court of Gujarat. In the case of High Court of Gujarat, within the Supra, the factual matrix is that the concerned person was appointed. Was that the draft recruitment rules was framed by the High Court, comma, which was pending for approval before the government. Full stop. The promotion of the person concerned was made on the recommendation of the High Court after considering all aspects of the matter. And in the said context, it was held by the Supreme Court of India that appointments can validly be made under the rules, even in the draft stage, if there is a clear intention of the government to enforce them in near future. Full stop. In the present case in hand, the factual matrix is distinguishable. Full stop. In this case, the government has not expressed its desire to promote anyone from the post of planning officer to the post of research assistant. Full stop. Had such an attempt be made, it could have been presumed by the court that the government has a clear intention to enforce the draft service rules. Full stop. Therefore, comma, the case of High Court of Gujarat within Venkata Supra is also not found to have the petition. Full stop. In view of the categorical finding of the court that the draft service rules were never acted upon. Comma. The court is of the considered opinion that no purpose will be served to deal with the cases cited by the London Council for the Higher Education Department and Department of Technical Education. Next one. Under such circumstances, comma, the petition fails and the same is dismissed. into order, comma, if any, stands vacated. Next para. Before parting with the records, the court is inclined to opine that in the absence of service rules covering in respect of the class of persons like the petitioner, there is every likelihood that there would be a hard burning in the in several of employees in the category, and therefore the court hopes and trusts that the appropriate authorities in the government will take a note of the situation where the employees are working without any draft rules or without any approved rules, which is duly notified, and therefore the court hopes that the government wakes up to the issue and resolves the same as early as possible, as early as possible. In this case, the court takes notice of the submission made by London Council for the petitioner that he would be superannuating in the month of August,
December.
December 2023. So therefore, the learned, therefore the learned standing counsel for the Higher Education Department and Technical Education Department shall transmit our order of this court to the concerned head of the department so as to enable them to take an expeditious decision on the matters. And if the I'll take a break and come back.
Which I have relied, my lord. I'll supply the photocopies, my lord. I will take my copy.
No, I'll give you after some time. Just
Oh,
let him
lots,
transcribe.
lots.
I have no use of this.
Lots.
Even Mr. Kumar, those judgment you have cited, after some time you can take it back because.
I'll take tomorrow, my lord. From
You take it.
obviously.
Matter relates to the appointment of a teacher in 1994. Then there was access teacher not in accordance with law. Then Manohar committee. It was after scanning of the Manohar committee, he was once again regularized
Yes.
and he was adjusted in a subsequent or another school. But while he went to join there, they found that there was a teacher present.
It was?
There was a teacher there.
Okay, okay.
Then he applied for readjustment in another school. That took a long time. In the meantime, further proceedings were staged in a proceeding. Read petition to koto?
5569.
5569 of 2002. There was an interim order of restraining everything and
Yes.
taking the plea. His readjustment was stalled. At that stage, my
You
lord,
are there.
Mr. R. Majumdar is appearing, my lord. He's on Lex in Court 5, my lord.
Okay, because his case has to be considered.
My lord,
It is not his fault.
But my lord, today I have learned that there is subsequent development.
Okay,
Possibly, I don't know at the moment at that whether he has been readjusted or he has joined another school or not.
okay. Just kindly stay for some time. If Mr. Mazumdar comes, I think he will have some instructions or he can get it.
Yes.
Even if you are not getting it, I think he will get
I
it.
agree. He will.
Just wait for some time then.
Yes.
Okay. Because he'll now be in verge of retirement.
Nine,
Well, item 9, one of the apology with folded hands, my lord. Lordship had directed me to file an affidavit on resolving certain queries. I've got the instruction yesterday only. And I have to draft the affidavit and will be sending for signature. If Lordship will allow me 4 weeks
That-
time, my lord, I'll get back.
That can be done overnight.
I can do this, my lord, but it has to be signed. Or otherwise, if your lordship relies upon the instruction, my lord, then is.
No, because you see, Mr. Ganguly must know where he stands. It may be adversely adverse to his interest.
Yes, that is why he
So
has to
therefore-
get a chance to counter with the
Yes, yes.
affidavit. And I apologize, my lord, I apologize. There is a
No,
order
you see,
from this.
why the difference in thinking is that perhaps in my earlier avatar, I was basically lawyer for private individuals.
Yes.
Therefore, drafting an affidavit by overnight was possible.
I could understand, my lord.
Correct. It is quite possible.
Here, my lord,
Well-
last 3 years, no material instruction. From
No,
the
but
government.
don't take so much of time. This is a 2017 matter.
I understand, my lord, because the new queries raised by your lordship, my lord, that for that purpose, to answer that queries, my lord, I had to take a fresh instruction. That is why it took some time.
Because we'll have to give you a stand.
My lord, at the next, on the next that fixed, my lord, will be coming
You,
with
you agree to a date when you will file it. Agree to a date. In 2017 matter, I don't like to make an adjournment.
that's what, my lord, I sincerely apologize for this.
No, it's okay. But give a date when you can do it.
Can it be on 1st June, my lord, Thursday, it's a hearing day.
No, what you will do is that by 29th of May, you file it. Correct.
Right,
Mr. Ganguly will have need at least 1 week's time to take instructions.
my lord.
So we give him time till 1 week will be 5th. Correct.
Lordship
So
will take a hearing date and. it will be
we
easier.
list it on 9th
My lord.
because by then affidavits can be served. Mr. Mukhtar.
Sir, everybody I will serve in advance.
No,
9 is a motion day.
we'll try to have it because you see, every day so many matters are being adjourned and fixed and refixed. Because those election matters are also likely to come up. I don't remember the dates on those hearing dates.
But after my affidavit, my lord, it will not take much time.
No, I
We'll
don't know.
clarify the issue.
I don't know that. This is for Mr. Ganguly to
okay.
take.
9 is okay.
9th is okay.
Lordship will mention this date, my lord.
I'll
Then
do it. Don't worry. All sides are duly represented. Mr. A. Samuel and a study council for the UGC submits that he has received instructions and needs 2 weeks time to file the affidavit in opposition. In terms of order dated 28/3/2023. Full stop. The affidavit by the UGC shall be filed within 29/5/2023 by serving advance copy thereof to the learned counsel of the petitioner. And you also, and to the learned counsel appearing for respondent number 4. Full stop. The court is inclined to give time till 5/6/2023 to the petitioner to respond if so required. Next list for hearing on 9/6/2023.
I'm obliged.
Yes. Mr. Mazumdar, in that Mr. BC Das's matter, you have instructions.
Here, this matter was Sometime in between, it was dismissed for non-prosecution. Thereafter, my lord, it was restored. I contact my office. We don't have a copy of the writ petition. Also, I tried to go through the orders on the last bit. But this case was somehow linked to another case, which was Bharat Chandra Sarkar case, my lord, which was challenging a cabinet decision for regularization. Then it was detect. And these all were dismissed, and now only this case has been restored. The others have not been restored.
No, because
That
you
is-
see, what I understand from this case, if I read singly, I don't know whether I have understood right or wrong,
My lord,
but his case is that he was adjusted in a school.
yes,
When he went to join, there was already a teacher.
yes,
So he asked for a readjustment.
yes.
And since then, it is in limbo, he is not getting it, his salaries and all are stuck
Yes.
because of that.
Now,
And now he was 44 years when he filed his writ petition
yes.
in 2010. Now we are in 2023, he's
64.
57 now. He's 57 now. So please get instructions, otherwise what is happening is that
Yes, madam. I had a discussion with the assisting counsel also. All these cases were taken up on that screening committee, and therefore the list 1, list 2, list 3 matters. I do not know whether it has been taken up as a.
We don't hear it.
The teacher. Sound doesn't go there.
Okay. Okay,
Now I have to confirm whether he has been offered appointment as a teacher or a tutor. But my lord, he has been because he due salary for 2 months. He has to be adjusted either as a teacher if he
No,
has.
but get the information, how much time you need?
My lord, Lordship will give me a week, my lord. I have the list, but I have to confirm whether he's accepted it or not. That
You get assistance from someone from your department, because if you start reading it, you not get it.
no, there's a long list, my lord. We just have to search the name. But I do not know whether he joined or not. I know whether he's offered or not. So that joining part I'll have to get from the school where he was appointed.
No, try to give us a date by which you can have the instructions.
A week's time would do, my lord. Somewhere on 25th would do.
Okay, so we are fixing it on 26, Mr. Das.
Ask you Bharat Sari, no? Yes.
26.
26.
Mr. B.C. Das and the senior counsel, assisted by Ms. S. Das, the counsel for the,
I just.
I Das, the counsel for the petitioner. Mr. He submits that he has not been able to get the present status of the petitioner. First of all, Mr. R. Majumdar, and standing also for the secondary education department. In this secondary education,
Well, this is elementary.
elementary education department submits that you will have to get the name of the petitioner verified from the list of teachers whose services were either approved or rejected. First of all, Mr. Das, this matter is from which district?
Bongaigaon.
First of all, the matter relates to the Bongaigaon district. The learned standing counsel for the secondary education, elementary education department may seek assistance of the concerned officials to track the status of the present petitioner and inform the court accordingly. Next para list on 26.
Well,
5,
can it be on subsequent day or?
Yes, yes,
25?
sure. 29th. 29th,
29th Monday,
yes,
Sunday.
Monday.
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 29th?
Yes, yes.
Okay.
Okay. 29.
Ablash. My lord,
Okay.
Yeah,
The government standing counsel for the elementary education department is permitted to send a download copy of this order to the concerned authorities to enable him to get the instructions.
But-
Yes, you were.
just to make things easy, my lord. Now we are councils for the Department of School Education. The directorates are different. So, my lord, so far as the elementary and secondary education is concerned, your lordship,
Elementary,
quotes-
secondary.
that standing council for school education, that will be enough for everybody, my lord, barring the higher education.
Please repeat again.
My lord, the department has now become the Department of School Education.
Okay,
So barring the higher education, that is Mr. Gogoi and his team, rest of us are all councils for the school education.
okay,
So elementary and secondaries are
Not
only
required.
directorates.
okay.
So that way, my lord,
Say
anybody
standing
can.
counsel, standing counsel for school education.
School
department.
education, then everybody is covered, my lord, even Mr.
Okay,
Aruna will be there, I'll be there, everybody is school education.
okay.
I'm not aware.
I tend to forget school because it is 83 I passed out. School is something I tend to
In
forget.
our time, well, my time, it was only the DPI. He was in charge of all the schools. Elementary, secondary, higher secondary. And at that time, the higher secondary was not there.
Right. I have today I have the advantage of senior Mr. Das, another senior Mr. Das, Mr. Mahanto and Mr. Datta. Just keep sitting down. Yesterday I was I got a news of someone who did not come home after the examination. Nowadays, with such a pressure of education, there are a lot of news coming in the
Yes.
media for this three persons newly implicated is
Yeah.
notice served on them.
I am for one football squad. In my case, Lordship, I want
No,
to place.
is notice served on them?
Yeah, other case, there are two cases taken. Other case, my learned.
No, no, my-
Agudi matter. My
no.
case, at this stage,
No, Mr. Barwa, my question is, has notice been served on them?
yes, yes. They are appearing on behalf of the.
No, no, there is a substituted respondents to 111213.
Yes, yes, yes. In my case.
Ajanta Borgoy, Ipshita Rajkumari.
Yes, yes, in my case.
Are you appearing for them also?
No, I'm appearing for it. The petitioner,
Petitioner on the dates of the petitioner, my lord, they were substituted, my lord.
Oh, acha, okay. Oh, I'm sorry. I was thinking it's a respondent. I was, no.
Therefore,
My
my
mistake,
case is,
my mistake.
therefore, my case is limited to a very small parameter now.
Yes. Yes.
I am not at this stage, and he's already been, my petitioner has already been expired. And my argument will be limited to his pecuniary service really. Therefore, my only point now is that
Substitution allowance from
No,
2005
not
to,
only substitution allowance, the lordship will find that the order impugned. The order impugned, lordship, we should find lordship. Page 230. in my petition.
order of compulsory retirement.
A compulsory retirement, lordship find that I have raised a legal point. That is that whether the dismissal or commercial any penalty can be given in retrospectively. Lordship will find here is the case. Lordship, I will give a just background of this case. The earlier occasion, the order of removal has been imposed on the petitioner. Thereafter, he came to this honorable
Because,
court.
I will repeat again, because reading singly is not very easy. I don't know whether I've understood or not. Here your case was that there was allegation of financial anomaly on you,
No,
and therefore alleging fraud and all, the disciplinary proceeding was no, okay.
no, I just give a background of this
Oh,
case.
okay. Yes,
The petition, there's a disciplinary proceeding, but very shortly I am saying, the disciplinary proceeding, the disciplinary proceeding is ended with a punishment of removal of the petitioner. And that order of removal was challenged before this honorable court. When the honorable court, or by its order, set aside that removal order, and considering the case of Israel and Ramzan case,
and the first inquiry, first decision has been directed to giving first decision. And thereafter, they have taken first decision after giving notice and so forth, and they pass the impugn order. 230.
Yes.
The impugn order also will find. What I am now saying is the penalty compulsory upon the services of the Dibrugarh University is imposed to the deputy account Dibrugarh with effect from 31st/12/2004. Order passed on 28/10/16.
Okay. That is the day when the fraud was detected.
Yes, that is my that any punishment. I will come with this at this point. Any punishment, either dismissal or removal, they cannot be given a retrospective effect.
Okay.
Once the petitioner removal was set aside by this court, one point is this, then and the no inquiry is the inquiry from a stage is given or directed to do a fresh decision. Then at that period, till the finalization of the decision on 28/10/16, he is deemed to be his service. Either by he didn't pay earlier occasion or pass order in the earlier occasion, he was put on suspension. Therefore, he will be treated as a suspension. And when the first order has been given, that order cannot give a retrospective effect. And this is because of the fact that if I am not on the penalty, if I am not now say he's already expired, I am not on the that way. My only 85 that the compulsory retirement order should be effected from 28/10/2016, the order passed.
Okay.
And then therefore then I will get the legal hair, I will get the entitled. This
Okay.
that is only limited.
Okay. Yes.
And my learned senior counsel will argue on this in different line or whatever. And for that reason, for that point, I will submit on this specific point. There is a apex court decision on a specific point, and that I will place before your lordship, and that apex court considering the two constitution judgment, they formulated a 3 point on that proceeding. That the same way that whether the employer bank and that is the bank have passed an order dismissal or the retrospective effect, whether they can pass, and whether the legal has the employee entitled to delay except I am on in pass, and I will placing that in time of and only limited purpose. My petition is on only place of the limited purpose.
You want to say that they should be made effective from the date of dismissal?
Yes.
Okay.
My one is that the order of that the compulsory, that is the first decision. Let's say we will just moment. If it goes to the order passed by this honorable court, is last operative part was 222 page 222. Just have a look closer then
Page?
page 222.
Yes.
Fine, was it last letter? Consequently, impugn orders of penalty imposed is however satisfied cause and matters remanded back to the decision order to take a fresh decision in the light of the discussion about the discussion is lordship will find it is as a nutshell only that para 31.
Yes.
And thereafter we have given the representation, so cause given, take a fresh decision. And that decision cannot be given retrospective effect. And the period after the judgment, which I will be after set aside my removal order, that period will be treated as I am in a suspension of that. That period must have been considered that I am in the deemed to be in service.
That's not.
And therefore, that is my limited period at this stage.
Okay.
And on that occasion, my learned friend will be, in fact, will be argue entire for proceeding. It is another case. And I am really only one judgment. Also, I am placed. That is 2014.
Where is the impugn order? Which page is the impugn order? In your case, which is the impugn order?
Yes, page 231, 230 below.
230.
230 below. 230. The impugn order lordship 230.
But Mr. Das.
Hello.
This compulsory retirement can't be made backdated.
Before the text, my lord, that's I am producing the instruction I have received from the university, my lord.
Yes.
Everything this retirement benefit that has already been accepted. That means when he has accepted this the retirement benefit, my lord, now he is enjoying this pension benefit, my lord. So whether he will be allowed to pursue the matter, he pay petition before pending before this honorable court, my lord. Since he has already accepted all the retirement benefits, my lord.
No, you'll have to, Mr. Das, you'll have to show us when did he accept that?
For that actually, I have to take my lord.
No, you'll have to do it because you see.
So no,
if you-
we have
if you-
changed that order.
if
Not
you-
issued, my lord,
No,
pursuant to the by this, by this, filing of this with petition, my lord. This after this, after filing the petition, my lord.
Oh, then it will not be, then it will not be what you call unqualified acceptance. Because once the challenge is made, that is why I'm
Not
asking.
that,
You see,
even
this
when
order
the-
of compulsory retirement is of 28/10/2016.
my lord,
This writ petition was filed in November
17.
2017,
17.
29 November 17.
My lord.
So if the acceptance is post filing of the writ petition, then your argument will not be acceptable.
No, my lord, because accept that even after the pending of this, he has already accepted this retirement benefit, my lord.
No, you see.
That
because-
both they cannot, my lord. Either he should forward the pension benefit or to pursue the matter, he, my lord.
No. You see, once a writ petition is filed,
Right.
that means the challenge has already been made.
No, that's ideal, that is
So
ideal.
therefore, there is no bar during the pendency of a case to accept some money, because otherwise you would have taken a discharge saying that you have no claim on that. If you can show that discharge,
My lord.
you get my point.
Right.
Because you see, I come from a background
Right.
where if I have a dispute with X, correct? I think I receive 100 rupees from him.
Right.
But he's paying me 2 rupees. I'll take the 2 rupees and then discuss with him for
partially, my
98. For 98. So therefore receipt of 2 rupees, unless I discharge him, of the liability of the others. This is not, it will be a matter of dispute whether the discharge is full discharge or this discharge is under protest. That is a subject matter which has to be heard.
No, in this case, my lord, when he says, if the petitioner himself has accepted my lord, if I pension benefit my lord, even after
No,
the
it's okay.
pendency of this petition, my lord,
No,
would
it's
that
okay. That,
he'll be allowed to pursue
no,
the
if,
petition, my lord.
that's what I'm asking you. If he has discharged the university,
Well.
unqualified discharge has been given, because once you give money, you take a receipt.
Right.
If he has discharged you completely, then you have a point.
Right.
But if the discharge is not is not unqualified, then what happens?
No. That part of the matter, I have to after instruction, my lord, because when he has approached the university, my lord, for settlement of this
Yes.
benefit, my lord. That
Yes.
I will have to collect the information, my lord.
Yes. Because
That's it.
you get my point.
But that I fully understand.
If there is no waiver,
Right.
waiver can't be presumed. It has to be explicit.
In
Yeah,
the
we
other
can
case
find
also, my
them.
lord, in the next case, my lord,
The- the-
in this
the
case,
order-
there was an order, my lord.
The
Right,
document.
right,
you also
to produce the
also,
record,
now,
original record.
Council also provided me the
disputed
document
proceeding.
which I'm giving to Lordship. And Lordship will find that or no, in communication itself, that was on 31/7/2022.
Retirement date.
That he was retired.
Retirement date.
He was retired on because it is a case of compulsory retirement, giving the retrospective effect. Here it says after the expiry of this, the petitioner, his family person member get. My question is that I am challenging that the retirement compulsory retirement order cannot be in the.
No. Mr. Das has a very strong point. Because this is something which I have also dealt with it in some matter. You see, when a discharge is unqualified, then this claim will go.
No.
You may have challenged it, but then you receive the receive the money. If the receipt is in full discharge of the debt, then
Lordship wants to indicate that whether I have waived my right.
Yes.
That also would the waiver and estoppel will not require, but waiver and estoppel is when come. I have challenged this order, challenged the order of that retrospective effect.
no,
Why
no,
ought
Mr.
to-
Barwa, this is very hard to accept because you see, if you accept the altered position, that can always be accepted. Altered position can always be accepted. You see, in a recent case where Karen's got a huge degree against the government of India from the International Arbitration Court of Arbitration. What happened? The government entered into a compromise and they accepted that the principal debt. So they waived their right. So if there is an agreement that even after discharge of even if you have a decree in your favor, you can still have the compromise. Compromise to receive money is not bad. Although you may have, the other side may have filed an appeal or may have challenged the decree, whatever. But then the power to compromise is always available.
Yes, that proposition I am agreed.
So if you discharge the debt,
The question is that now here is the question is that Lordship, that the compulsory, we have changed the compulsory retirement order. Very simple, compulsory retirement order, the petitioner, before he is expired, is the compulsory retirement. The matter is pending here. We challenge that order. Only on the ground of prospective and retrospective. It is a question of law.
no,
And thereafter,
that is okay,
Lordship,
Mr. Barwa.
whether I
No, Mr.
have
Barwa.
received the amount.
No, Mr.
No,
Barwa, I'll
but-
tell you why. Since I come from a civil background, the civil concept is always there in the mind. You see, what happens is that only when you have a decree, then Order 21 says that the money paid against a decree should be discharged. The discharge must be in accordance with Order 21 Rule 2. So if that, supposing when you have a decree, and then the payment you are accepting not in terms of order 21, then it is no payment at all. Correct. Your principal decree remains. But if the discharge is in accordance with order 21, then proportionately, if you were to receive 100 rupees, you have received 2 rupees. So then you are entitled only for 98. So the adjustment will only be made if it is in accordance with the provisions of order 21 rule 2. That is why you see, here is a case where there's a order of compulsory retirement. You are retired at a anterior date of 2004. You have challenged it. But despite the challenge, when you accept it without any qualification,
That is not.
that is called an acceptance without demur. In contract, it is called acceptance without any demur.
That is why I want to draw the attention of his their letter. What this data says, this case was pending here. After this order 16, the case was pending. Thereafter, the petitioner expired when COVID or expired. Here said thereafter, the normal course of retirement, as they have said it here, 31/7/2022. Normal course of retirement. Thereafter, what they say in here, that cannot be sustainable. You giving the compulsory retirement from the date of entire date of 2004, now we say that he is retired on 31/7/2022, and the family, we have given the pension to the family person.
I'll show you.
We're giving the to family pension.
I'll show you.
How it can be?
I'll show you. Mr. Barwa, I'm sending you this evidence act. You see, admission, it is defined. Now, you'll have to show that this admission is with an intention, section 18. It is with an intention to bind. That is number 1. Because this communication, there's another aspect to it, Mr. Barwa. It is only for academic purpose I am discussing, because this is not a matter in issue. You see, a communication between the registrar and the council is a privileged communication within the meaning of I forgot the sections 122 or 23 something. Correct. It is it's a privileged communication, number 1. So therefore, it's not an admission; it's merely an instruction to him.
Not admission. Okay.
So therefore, when it's not within the meaning of section 18,
Yes.
the fact remains the everything will boil down to only one thing. If the discharge, if Mr. Das can show that the discharge was made, then you fail. And if he cannot show that the discharge was made by you or your predecessor in interest, then the university fails. Out of the two, one will not succeed.
Right.
Let him get that instructions.
Yes, notable fine. Here is the case, petition is filed. Doesn't fine. The record, they have they have to show the record.
Yes,
So record that I voluntarily.
that's what we are asking.
Yeah,
That's what we are asking.
Number one. Number two is that watchable fine. I want to test. That is one aspect of this matter. This petition, I am confined to this petition. This petition is filed challenging the validity of the punishment, the order passed by this. Even if this order is not in accordance with the law, then what will be consequence? The consequence will be that I will be get the pensionary benefit from 2016. Even if possible case that if some amount has been taken by me, even during the course of time, then that will be adjusted. Because it's an unlawful order, it's an unlawful order.
No,
It
then you
on-
are wrong.
Is a law.
Then you are wrong. Let us, we can test one way.
Oh.
Will, you see, unless I achieve an end, there's no point continuing the discussion. You see, number one, you can take a chance. You argue with the presumption that Mr. Das has with him your discharge. Correct? And let me proceed with the matter in the what you call in my final decision. But you see, because the fact remains is that a discharge, if it is not under protest, it's a full discharge. And it's not only a decision of this court, there's also a decision of the Supreme Court of India. So therefore, if during the course of litigation, if you have made a payment and you don't accept it as a part payment or on protest, it would amount to a full discharge. And I have decisions with me on the point. So therefore, the two options available is that I give time to Mr. Das to obtain the discharge, or we proceed on the premises that he has no discharge of, he has a discharge of you, and then we proceed with the hearing.
And that will be on record will say, even
If it is for the record, then we'll wait for the record. Then there is no point in
these are the record.
continuing the hearing.
But your lordship is the fallen from your lordship mouth. My lord, if there is any positive discharge.
Mr. Datta, nobody can know more than you in this matter, because in insurance, you always deal with the discharge given. Correct? If somebody gives a discharge, which is in full and final settlement, then that becomes an admission.
Yes.
Correct. So nobody will be more equipped than you when it comes to receipt.
What I propose, my lord,
Yeah.
if it is there at all, my learned senior friend can.
Because
produce
then
that.
there's no point in continuing with the discussion.
I do accept that proposition. And further, my lord, possibly my learned senior friend doesn't have the record also. The record of the case. which
He'll get
proceeding
it.
will be
He'll get
necessary.
it.
No, my,
Mr. Das is one we can rely on him. If he
Yes,
says there is,
We have
there,
tremendous respect, we hold him.
so this is no
all
issue.
respect.
only actually my last, I could not collect the these records of the decision proceeding because of there are some education program was going on in the Dibrugarh University, my lord. For that actually, they could not send the records, my lord.
By next week, you can get it by fax or something,
Oh.
this by WhatsApp or something. This,
Let it be my lord, after
discharge?
2 weeks, my lord. Let it be after 2
you
weeks.
choose a date, there's a calendar in front of you.
My lord. Let it be on the 25th, my lord.
Okay. Okay,
Oh, no.
Mr. Datta, 25th, acceptable to you?
25th.
25th, my lord, 25th, 26th, I will not.
You will not be there. Okay, you choose a date, both of you agree to a date, Mr. Datta.
My lord.
There's some disturbance in your, you can't hear his voice. Please come over, you just have a
Yeah.
discussion with him. Any date convenient to both of you. Achha, why this voice is not coming? This can't hear.
Maybe because oh, sorry, any day.
ওটাতে 2 এটা দিব লাগিব কি স্পিকার কারণ কথা দেও বুঝি না পারে হ্যাঁ এবার বুঝি পাবেন
30th, my lord,
My lord.
I just.
That is a hearing day, my lord.
30. Just check up.
Oh.
30, okay. But Mr. P.P. Barwal and counsel for the petitioner. We read separate orders, huh? There are two matters here. The counsel for the petitioner. And Mr. N.C. Das, the senior counsel for the Dibrugarh University. Assisted by Mr. A. Das and counsel. Next, at the outset, the learned senior counsel for the Dibrugarh University has submitted that during the pendency of the writ petition, the predecessor in interest of the petitioners had received his retirement dues. Next, the stand of the learned counsel for the petitioner is that once the order of compulsory retirement has been challenged, the subsequent acceptance would not prejudicially affect him. Acceptance of money would not prejudicially affect him. Next, be that as it may, in view of the submissions made by learned counsel for the senior counsel for the respondents, an opportunity is granted to produce the record relating to clearing of dues of the predecessor of the petitioners. Next, as agreed to by both sides, list on 3/05/2023.
Right.
In your matter, we just adjourned it.
Yes.
Your submissions are not same in this case. In Mr. Datta's case,
No. No, in his case, my lord, I was directed to produce the record, my lord. This was matter was heard by another bench, my lord. And
okay.
after hearing that, I was directed to produce the record. my
No,
lord.
My case,
No,
entire record is not required, only
No,
that part.
not that. In Mr. Datta's case, are you taking the same plea of that he is
Yes,
taking the
my
money?
lord. I am holding the paper also, my lord.
You are also taking, then write the same thing here. Just add in the next case, Mr. S. Datta, and senior counsel for the petitioner, along with K. Upamanyu, counsel for the petitioner. Same thing.
Right.
Okay.
Published to lodge.
With that background, it's at times it becomes difficult, Mr. Parwar. Yes,
Because the fact that before taking the retirement benefit, my client already been expired. They
No,
only
that is,
provide for
no,
it.
that is okay.
Interesting point, my lord.
That is
We shall
okay.
also educate ourselves on that.
That is okay, but there are certain concepts which I'm carrying is very hard to what you call throw it out. At times,
Interesting point.
but this is subject, this is something I have dealt with it. That's why I'm quite acquainted with what is an admission, what is a discharge.
Yeah.
What is a protest discharge?
Lord,
Because it is called discharge
be
under
happy.
protest. Huh?
We shall be.
We'll also end on that, because of the one fact that very recently I have gone to a judgment of the waiver estoppel I have placing in the education department case. There I have said, getting a specific Supreme Court said that for the waiver and estoppel, the person have to first know that there is a legal remedy for him to assert that part. But here is the case you already asserted. That is it. Then the waiver and estoppel is not part of us.
Please that judgment.
Therefore,
I
what
agree.
what I'm saying, let us educate ourselves also on that, so that we can address your lordships. And if
No,
we-
you see, I am too small to suggest that. You are otherwise also learned. I won't say that you have something to learn, but yes, in the process, I have to gather some more.
This is a field, my
Very good.
lord, learning never stops. So
you
therefore,
know.
There is no any end, but
Okay,
Which
next
item?
item,
published.
next item,
obliged.
part 2. Part 2, then we'll start, there's a part 2 now. We'll start at 2 then. Resume 2.